It's 9 a.m. This is the 8th meeting of the Bills Committee on Mandatory Reporting of Child Abuse Bill. I call to order the meeting. Let me first invite the representatives of the government to join us. I'd like to thank you all for attending the meeting on a Saturday. We're supposed to end at 1 p.m. However, if there aren't many controversies and we can proceed efficiently, then maybe we can end the meeting earlier. While we wait for the government officials to join us, let me tell you about how we're going to proceed. I hope that all members have a chance to speak if they want to. Hopefully, we're able to finish the clause-by-clause scrutiny of this bill today, as well as the CSA submitted by the government. I hope we can finish all these procedures within the meeting today. We have 4 hours. We may be able to wrap up the meeting after we've scrutinized the blue bill. There is a part of the bill that says that the director may issue a mandated reporter's guide for the reference of the court. The guide should be discussed by members, and the government will fulfill its promise to submit this guide, and hopefully the guide will be submitted by the government by May, that is within this legislative session. And hopefully we'll be able to discuss this guide. We'll only have a discussion on this guide. We're not going to scrutinize the content of the guide. What is most important today is that we are going to finish the clause-by-clause scrutiny of the bill as well as the CSAs. We're going to tentatively hold another meeting on the 1st of June. There will be a preliminary draft of the mandated reporter's guide from the government, and we will have a discussion on this. Again, it's not an examination or scrutiny of the guide. After we finish the discussion of the guide, I, as the chairman of this Bills Committee, I believe we will have completed our mission. Now we officially begin our meeting. I'm not going to read out the names of each government official here. Let me invite Mr. Ho Kai-ming, Undersecretary for Labour and Welfare, to brief members on the latest progress. Before we proceed with the clause-by-clause scrutiny, I'd like to talk about the CSAs we submitted. Based on what we discussed in the last meeting, we submitted LC paper number CB bracket 2661/2024 bracket 01. It includes some draft CSAs. This includes adding a new schedule to explain what constitutes serious harm, and also the relevance of the mental element. And we're going to turn certain defense provisions into exclusion provisions. We're adding a new defense provision. We're also introducing a 2-tier penalty system. This is a suggestion made by Mr. Lai Tong-kwok. As we scrutinize the bill, we will give a detailed account of the CSAs. We will provide a response based on the comments made by members. Will also, as chairman said, provide a preliminary draft of the mandated reporter's guide. If chairman allows, should we proceed with a clause-by-clause scrutiny? Well, before we do that, I see that two members have questions. 3 minutes for each member, Ms. Lillian Kwok and Mr. Lai Tong-kwok. Thank you, Chairman. In the past meetings, we mentioned about the standards of making a report. Clause 6 mentions that mandated reporters have to make a report using a specified form. Does that mean if reporter cannot make a report without filling out the form? Does that mean a report is only filed after a form is completed? I want to know government's take on this. The administration, I'd like you to give a brief response. I suggest that we give a response when we come to clause 6. Well, I hope by then you'll be able to directly address Ms. Lillian Kwok's concern. Next, Mr. Lai Tong Kwok. The government has submitted the draft committee stage amendment. The CSAs are quite clear. If we only stick to the blue bill, it might be confusing. Can we proceed with the clause-by-clause scrutiny with the draft CSA submitted by the government? This might make the process smooth. Legal advisor, please give us some comments or advice. We may look at the latest marked-up copy submitted by the government because there are CSAs included in that marked-up copy. Would members agree to this? That is, we only stick to the CSAs for the parts amended. All right, thank you. Dr. David Lam. Thank you, Chairman. I thank the government for the CSAs. From Schedule 1A, I don't see any use of drugs or substance on children. You mean under the definition of serious harm, right? Say a parent give cannabis or cannabis candy to his child. This kind of situation is not covered under Schedule 1A. Yes, I thought of this scenario as well. Administration, please. We will explain it further to members when we come to that part. For the parts that have been amended, I suggest that we stick to the CSA. Well, members are concerned about the provisions as well as the clauses. Well, why don't we proceed with the clause-by-clause scrutiny now? In the previous meeting, we stopped at clause 3. In the government's CSAs, I see that a new definition has been added. Administration, please walk us through that part. I invite Ms. Jean Chan to tell you more. We added a definition for responsible person in the CSAs. Let me invite my colleague from the SWD to explain to you the definition of responsible person. Yes, definition of responsible person. We made reference to Cap 212. Section 21, bracket 1. Anyone who gives care to a child can be regarded as a responsible person. Relatives or nannies of a child can also be deemed as a responsible person. Any questions on this? Yes, Mr. Lai Tong-kwok. Thank you. I have a few questions. First, is there any scope concerning responsible person? I see there isn't a scope. Say someone is responsible for the custody, charge, or care of a child, then that person is considered a responsible person. The age of that person is irrelevant. Say a mother is 17-year-old and she takes care of her children, and that mother must be regarded as a responsible person. Is that the case? Say a mother asks his 15-year-old son to watch his little brother. Would the 17-year-old son considered as a responsible person then? SWD. Mr. Lai understands it correctly. According to Cap 212 Offences Against the Person Ordinance, that person can be over 16-year-old, and if that person has the custody, charge, or care of a child, then that person can be deemed as a responsible person. Chairman, the administration brought up Cap 212. How do you make this bill in line with Cap 212 so that we can use Cap 212 to understand the definition of responsible person in this bill? Perhaps can you tell us what are the instances in which responsible person is mentioned in Cap 212? Chairman, we added this definition for Clause 4, Bracket 2. Can we have a further explanation of what responsible person mean when we come to Clause 4, Bracket 2? Well, Chairman, the administration brought up Cap 212. I'm saying how we're going to compare the two legislations as we understand the meaning of responsible person. What I understand is that we have to use Cap 212 to help understand or interpret the meaning of responsible person. DOJ, any response on this? Chairman, we will look into whether we have to add an age requirement for responsible person. What Mr. Lai is saying is that we're adopting the definition of responsible person from Cap 212 Offences Against the Person Ordinance. However, this ordinance is not cited in this bill. Well, this is because this bill looks at children aged under 18, and you're saying that responsible person cover children aged 16. Well, if Cap 212 is not cited in this bill, we cannot directly make use of Cap 212. If it is of the department's view that we have to cite Cap 212, we may have to mention it in the bill. Chairman, I have another question. According to the CSA, responsible person is someone in relation to a child, which means a person who has the custody, charge, or care of the child. So a person does not have to go through any statutory procedure to become a responsible person, right? Say a child is under someone's custody, charge, or care. This is a fact. It's not like a person has to go through any statutory procedure to prove that person's relationship with the child. Say a father of his child is a responsible person. And if the father gets divorced with the mom, then the father is no longer a responsible person of the child. So are we judging whether a person is a responsible person based on the facts? After the government makes a response, I'll let Dr. David Lam to ask his question. I thought of a news. A man lives on his own and his neighbor is a single mom, and that single mom always asks this man to help take care of her children. Would that man be regarded as a responsible person? Administration. Well, Mr. Lai understands it correctly. The example raised by Chairman reminds me of another case. It is in Mongkok, and a mother asked her friend to give some drugs to her children, and that caused a serious impact, and we invoked Cap 212 offenses against the person ordinance to press charges on the mother. Well, the friend of that mother is not regarded as a responsible person, but based on facts, we decided that the friend at that time served as a responsible person of the child concerned, and we instituted prosecution. Based on the current child abuse guide, we deal with child abuse cases like this. Dr. David Lam, 3 minutes. I'm looking at clause 4, bracket 2 and bracket 3. There are certain situations under which a mandated reporter would not have to report a case. Say a mother asks her 15-year-old son to take care of her 3 or 4-year-old child. Would that mother be responsible for such a situation? Dr. Lam was talking about clause 4, bracket 2. Well, we stopped at definition. Perhaps we can respond to Dr. Lam's question when we come to clause 4. Mr. Peter Xu. Thank you, Chairman. I'd like to ask about the definition of responsible person. According to Deputy Director, after the passage of the bill, say a mother asks another family to help take care of her children. If there is any neglect, the people would have to be responsible. Well, before the passage of the bill, at this moment, say a mother asks her neighbor to take care of her 4-year-old child, and if the neighbor, when the neighbor is looking after the child and the child falls from the bed and gets injured, would the neighbor be held accountable? And after the passage of the bill, would the responsibility of the neighbor change?
It's the duty. If a neighbor takes care of the child, if the neighbor promises the parent to take care of the child, then there's a responsibility. In the case of neglect or child abuse, well, currently we follow the existing guides to follow up the case. Here in the bill, what we are talking about is mandatory reporting. When there is a neglect of care or when there is a child abuse scenario, the bill will not affect the follow-up of the well-being of the child. So the thresholds, the standards are not to be changed much. Yes. So in relation to the definition of responsible person to be added by way of the CSA, well, first of all, it's established that we will establish the status by way of the facts. Secondly, well, you will be aligning the definition with Cap 212. In other words, we are talking about anybody who is aged 16 or above. Am I right in my summary? All right, the DOJ has said that they have to go back to consider the matter carefully with the Bureau as to whether the existing drafting can imply that this will be read together with Cap 212. So please come back to us on this. So regarding responsible person, do you have other questions on the definition? No? Then we will move on to Clause 4 then. That is Part 2, mandatory reporting. Administration, please. Thank you, Chair. Part 2, mandatory reporting. Please also take a look of paper CB bracket 2661/2024 bracket 01, draft CSAs. For Clause 4, when must reports be made? If it is not serious or if it is not in the course of the work as the specified professional, then please take a look of 4.2. There is a specified profession is not required to make a report if there are certain conditions. Well, if it is suspected that a person, that is the child, has been suffering serious harm or is at real risk of suffering serious harm, then the professional must report. In fact, the two scenarios would cover all the urgent scenarios, and there is substantial substance. If we are to cover child abuse cases in the past and the serious harm no longer exists and the real risk of having another instance of serious harm is slight, then it will add to the pressure on the professionals, and it will also thin out the resources without helping to protect children from serious harm. And in fact, if somebody is suspected to be at real risk of suffering serious harm, it means we can cover children who are not actually suffering from serious harm but is at real risk. All right, in relation to Clause 4, bracket 1, any questions? Two members have raised their hands to speak, Mr. Lai Tong Kwok and Ms. Lam So Wai. I'll give you 4 minutes for Q&A. Well, I think this is the most important part in Clause 4, so please allow me sufficient time. Yes, you'll be given several rounds of questions. Clause 4.1. First of all, in relation to this offense, is it a matter of strict liability? In other words, under 4.1, there isn't anything in relation to mens rea, right? Administration, please. Thank you, Chair. Thank you, Mr. Lai, for his question. We did look at the case law. Comes to the notice in relation to the suspicion. Well, comes to the notice is the mens rea, according to the court. So if there is a reasonable ground to suspect the following comes to the notice, then it is not a matter of strict liability. If the specified professional fails to report, the prosecution must prove the ground to suspect and whether it is reasonable, and whether a person would have a reasonable suspicion. So the reasonable ground to suspect is the mens rea. So in this case, it is not a strict liability. Mr. Lai, thank you, DOJ, for being so poignant. So he has given us the essence of the bill. Comes to the notice, that's the mens rea. And then there is reasonable ground to suspect. Again, this phrase is very important. Comes to the notice. I want to know whether that's the essence of the mens rea and the actus rea. This is because if it's a specified professional during the course of his or her work as a specified professional, if it doesn't come to his notice, does it mean that he hasn't got the duty to report, even though the prosecution thinks that in such a scenario, there's no way that it hasn't come to his notice? And this person cannot be convicted. So comes to the notice. Is it a subjective test? If it is subjective, then what about my question? Does it mean that the prosecution must prove that the specified professional during the course of his or her work and at the material time does come to his notice? Please comment on my observation. Yes, Mr. Lai is totally right. We have to prove that that specified person does have that coming to his notice, and this will cause a reasonable specified professional to have a reasonable ground to suspect. But then as to whether something is so obvious that there's no way that if he fails to notice, then it depends on evidential evidence, and for the court to say whether the court would take the word of the specified professional that even for something so obvious that he hasn't noticed that. Well, in that case, it is no longer subjective. You are saying that any reasonable specified professional in the same scenario would have noticed. Then it means that it is an objective test. That is the reasonable man standard. Please bear with me for using the term in English. So please sort out clearly that it comes to notice whether it is something subjective or not. The prosecution has to prove that. Let me cite an example. In a case, the specified professional carries out an examination. He has noted down injuries, bone fractures, etc. So he knows that it has come to his notice. So he has jotted down the notes. On the other hand, a child will have his clothes removed when a specified professional examines him. But if that professional doesn't remove his clothes, then he would not have noticed that. And then you cannot prove that it has come to his notice, and then the case cannot continue. Mr. Lai is right. Let me clarify, that is, whether it is subjective in terms of the coming to the notice. Well, if there is direct evidence, like he has written down some notes, then this is rather direct, straightforward. Sometimes it isn't that straightforward, and we have to rely on circumstantial evidence. So it's a matter of adducing the evidence to prove that it has come to his notice. Next, Ms. Lam So Wai. Thank you, Chair. Clause 4.1. provides for the specified professional during the course of his or her work as a specified professional, do you think that it is too restricted? Say, for example, I'm a social worker. My working hours are between 9 and 6. On my way to work, I see somebody who is suffering from abuse and he or she is a child. Does it mean that I haven't got the duty to report? So it mentions during the course of his or her work as a specified professional. Well, Chair, this is about mandatory reporting. So during the working hours of this professional, then he must report. Outside his working hours, our system is still open to him or her to make a report. But then outside his working hours, it is not a mandatory reporting. Outside his working hours, he may be a parent, he or she may be a parent or a neighbor. He observes something, he sees something, he's not mandated to report, but he can still make use of our system to report. So the bill relates to something observed during the course of his or her work as a specified professional and clarifies who must report. 41B, at a material time, the child has been suffering serious harm or is at real risk of suffering serious harm. The professional must, as soon as practicable after the reasonable time, make a report in respect of the child in compliance with Section 6. Material time. After the material time, what does it mean? Does it mean that after the child has suffered the serious harm or has gone through the real risk of suffering serious harm and then I report? Probably that's not the legislative intent of the bill. So does it mean that you have to amend it so that it is tidier? And then as soon as practicable, make a report. What does it mean? What is as soon as? And what does it mean to say as soon as practicable? Do you need to qualify it in this way? As soon as practicable, that's too subjective. Can I claim that I'm in a rush to finish my work, so I'd rather leave it tomorrow? So you say after the material time. What is the material time? Does it mean 24 hours, within 24 hours? In the past, for incident reports, I had to do it within 24 hours when I used to work as a social worker. Can I say that I can leave it as I'm in a rush to finish my work? Or would you say that it is important to protect children? Now, we aren't talking about policy advice. You have to be very careful about your wording. So after the material time and as soon as practicable, don't you think that you should sort of fine-tune it? Secretary. I'd like to thank Ms. Lam for her advice. In the course of our discussion with the Bills Committee, some organizations did say that they would like to be given flexibility. Our wish is to have it done ASAP. So as soon as practicable, for child abuse or abuse of any nature, the actual nature and complexity would vary from one case to another. So we can't draw a rigid line and spell out a deadline. So we'd rather leave it to the judgment of the professional. Maybe the DFJ and the SWD can comment on the material time. Let me talk about the operation. As far as timing-wise is concerned, we would like to keep the flexibility. As the Deputy Secretary has said, child abuse cases vary, so the reporting time may vary. In the case of a physical abuse, the certified professional has to call for an ambulance to come and take care of the child's injury first. So it may be a matter of having it done within an hour's time. For sex abuse, the girl's case comes to the notice of the specified professional. The girl may be in a very emotional disturbed state. She may be suicidal. The professional may have to deal with the emotional condition first, and it depends on the location. Maybe the girl is in a camp and you need to have a judgment or an assessment overnight, so the professional may need more time. So what we want to keep the flexibility so that the professional can deal with the professional duties first. As soon as practicable, sometimes we want to give flexibility if, say, something happens the night before. Well, as long as they can tell the court, they can tell us that the professional has made the report as soon as practicable, then he or she has already met our requirements. J. Thank you, Chair. Material time is defined in Clause 6. As to the real risk, at the material time, there is real risk. It doesn't mean that the real risk arises. So he has to make a report as soon as practicable in that case. Well, making a report, to be frank, Ms. Lam, please be concise in your follow-up question. Well, Director, we work as a team. It could be the case worker making a report, but it might be the psychologist dealing with the child. If you haven't got a time frame, if you haven't got a deadline, it could drag on for a few days. Now, J said that there is no need to worry about. Maybe we have to deal with the mental stage, emotional stage first. But then what about a time frame? Would you say 24 hours? You expect them to fill out the form. So would you impose a time frame so that they won't drag their feet? Administration. I think earlier on in this chamber, we said that in special cases, we have to deal with the emotional state of the victim first, say, for example, in cases of sexual abuse. So we rather allow the professional to take care of the child's well-being first. And that's why our bill is worded in such a way that we don't impose a very strict timeline. Otherwise, for very complex cases, like when a child is emotionally disturbed, we're still insisting on making a report to the police. We'd rather wait till the child is emotionally stable before we make a report, so we keep the flexibility for the professionals. Well, for the mandatory reporting mechanism, are you going to elaborate on the requirements if the professional notices and there is a reasonable ground to suspect? I want to know whether the mandated reporter's guide would cover this. Yes, we'll try. We'll try to list out the scenarios in the guide as to what would call for instant reporting. Thank you. Next, Dr. David Lam. I have some observations to make. As soon as practicable, I agree that we need to keep the flexibility. It is also a matter of professional judgment. The flexibility is not unlimited. It's a matter of professional judgment. If it is believed that it is reasonable, then it should be acceptable. You may think that it is too long, then it could be regarded as a question of professional misconduct, and you can follow that up as well. Now, for a professional, in the course of his or her work as a specified professional, and a reasonable ground to suspect comes to his notice, then it means that it's a matter of professional conduct. In other words, like a child comes to see a doctor, and he complains of a stomachache, and if the doctor fails to remove his clothing, and therefore he fails to observe the bruise on the stomach, on the tummy, then it could have been a matter of professional misconduct. You may very well say that it is subjective, but still there are objective rules concerning the professional conduct. So it isn't the case that the doctor, the professional, says that it hasn't come to his notice. We won't allow that. What he or she does must measure up to the professional standards. Any need to have a reply from the administration? No. Thank you, Dr. Lam.
Mr. Teck Shi-yun. Thank you, Chair. Because I came in late, so if my question is already repeated, then please just ignore it. Normally speaking, we would like to engage professionals to help protect the child. We are not trying to force them to do their job well through severe punishment because it is going to cause some adverse effects. In that case, they will try to protect themselves by abusing the regime, which is undesirable. I believe that there are 3 levels for us to consider. First of all, that is the mandated reporter's guide. Of course, we have an expert committee to prepare the guide. Hope that there will be more communications with the professions. The frontline workers are very important. Second, would you ask for the institutions to put together some internal guidelines because each of them have different environment? If you only offer them one set of guidelines, it might not fit the different situations of the institutions. Would you require different institutions to put together some standard procedures guide? I think it will symbolize some reasonable expectations. Would SWD discuss with the institutions requiring them to put together such an internal guide? Third, professional judgment. I think we can reinforce this part of the profession through experiment and some on-the-job training. If we can offer them such a guide and some trainings, it will be truly helpful to our client. We don't have to just focus on the procedures. We really need all these different levels to ensure the professionals are really ensuring the protection of child. Any response to the question of Mr. Teck? Thank you. Just now you have covered a broad scope. I suggest that we can cover that in our next meeting when we discuss about the mandated reporter's guide. The institutions can take reference to the legislature as well as our guide for their internal guidelines. We are only at clause 4 now. We are focusing on the wordings, so we will not specify the responsibilities of each institution here. Is there any expectations from the administration? But of course, it will be relying on the institutions to put together such a guideline. Do we believe that the institutions have to do such work? The legislature has to target it at each registered persons. The employers has the responsibility to support the staff to fulfill the responsibility. So we will leave it to the institution. Mr. Dick, this is your first round of questions, so I would allow a rather broad scope of questions. But actually, we are already in the procedures of clause-by-clause scrutiny. Mr. Lai Tong-kwok, second round. Just now, Ms. Lam So-wai has mentioned about as soon as practicable. As I understand, the court would normally take an objective test. That is, for any specified professionals, he or she would take certain actions under the same circumstances. Let's say, according to the court, the professional has to report within a certain time frame. And then we apply the principle in that particular scenario to see if the reporting is done within a reasonable time frame. This is normally the standard. As far as I understand, we apply it in such a way because if the wordings are too strict, people might break the law inadvertently. So the wordings would be rather broad. The court would adopt a third-person objective test for scrutiny. So my actual question is, clause 4, bracket 1b1. As the administration mentioned, at the material time, a person is a child who has been suffering serious harm or is at real risk of suffering serious harm. So has been suffering is in the tense of present continuous. In Chinese, it is very clear. The responsibility of reporting is only limited to the working hours of the professionals who come to the notice that the child is already suffered from serious harm and is still suffering serious harm. So there are two requirements. Let's say one specified professional has come to the notice that a child was being beaten up and they are already swollen in their face. That means the child has already suffered serious harm. Then the professional do not have the responsibility to report because they are not still suffering such harm. I understand the explanation from the administration, but you have to imagine, under such circumstances, these wordings indicates that it is not enough. It is not enough to have the child who already suffered, but they have to be still suffering. Do you still believe that reporting is required? This is an imagined case. Let me put it this way. Let's say a member of the family got drunk for the first time and they hit his or her child very harshly. Normally, this person is a very gentle person, but it happened for just once, and he also promised to quit drinking because that child was only being hit for that particular night. But you said has been suffering, so how can we interpret that? The administration. The reason why we put together the MRR is to hope that we can have early and precise detection and intervention for the urgent case in order to protect child. So in clause 4, bracket 1, bracket A, it stipulates 3 time frame, the past, the present, and the future, which include 2 types of scenarios. First, according to Mr. Lai, the child had suffered that is past and is still suffering that is now, or is at real risk of suffering serious harm, that is the future. So putting together these 2 scenarios, there will be 2 legal effects. First, the ordinance will cover the child who is still suffering serious harm, that is present, or the child who is at real risk of suffering serious harm, that is future. On the other hand, the ordinance will not cover child abuse cases that only happen in the past. That is, the serious harm no longer exists, and there is no real risk of suffering serious harm. In other words, the clause is to divert the focus of the caretaker on these scenarios, that is, some present cases. Because if we include all the cases that only happened in the past, and those cases no longer exist now, and there is no future risk, if we include all that, then the specified professionals will be very stressed. It will also diverted the resources of investigations. It is also not that helpful in fulfilling our objective. I would like to cite once again my fictional case. The professional would judge that that particular person is still is a very gentle person, they will not overdrink again. Although that child is seriously harmed in this case, they believe that it will not happen again. In that case, the professional is not mandated to report. But will you still prosecute the person who hit the child after being drunk? Will there be any differences? Because there are different thresholds between the abuse case and the reporting of child abuse case. Thank you, Chair. May I supplement to the concerns of Mr. Lai? Has been suffering serious harm. It focuses on the definition of serious harm because we are focusing on the consequences. In the example of Mr. Lai, it said that if a person is already injured on his face, but the beating is not occurring anymore. But when it comes to the notice to the professional at that case, then the child has been suffering serious harm because we're talking about the consequences, not the action itself. As for the case of the chair, even if it is just a one-time incident, if that is bone fracture, then it is already a serious harm. If the professional come to notice that there is bone fracture, although they pledge that it will not happen again, then the professional would still have to report because there is bone fracture. Is it a consistent understanding between departments? In terms of operation, it will be very complicated. According to the example of the OJ, it talks about the existence of bone fracture. If the specified professional cannot test on the injuries of the child immediately afterwards, according to the administration, or if it is in the past, then it is in the past. If the child is recovered from the harm, then the harm no longer exists. It draws to other questions. Under what circumstances can you regard a harm as no longer exist? How can you define recovered? It is very difficult for you to specify. All that we are looking for is just one thing. That is, you have to report these cases if you spot this and that. This is all the legal responsibilities that you have. The only question is whether or not you need to report. Because after that, you still have to take care of the case. As Cha mentioned, it is a one-time incident and the child is injured. 2 weeks later, at the follow-up checkup, the doctor would think that it is no longer required to be reported. Are we missing out something? I have listened to the comments from many professionals. They all expressed that protecting child is our highest priority. If you execute it in such a way, it is quite likely for you to miss out. That is all because of your wordings. Is it an ideal situation? It is something that worth considering. Is it really necessary? Any immediate response? Yes, Chair. Thank you, Mr. Lai. As Ms. Jin Chang has mentioned, we are only trying to rule out some serious harm that happened a long time ago. It is out of our reach. If it has happened already, then there's nothing we can do because we can't help them. If they are already recovered and then the social worker may notice some scars, but they are no longer physically harmed, then we will exclude these cases. This will not be our priority because the child is already recovered and what's left is only the scar. In that case, the professionals will not have a mandatory reporting responsibility. if the professionals believe that the child was harmed and believe that they are at real risk of suffering serious harm, then it fulfills the situation of 4 bracket 1b2. Because if the professionals still judge that that is a real risk, then they still need to report. But our legislative intent is to rule out some harm in the history without present risk. Although there are scars, but that child is not at risk. I would like the SWD to supplement about the practical execution. If we discover scars and bruises, we would know that perhaps the mother has some emotional reactions after divorce and therefore causing bruises on the child. It could be a one-time incident and the child is not emotionally or physically harmed anymore, then we will just follow up the case according to our standard guidelines. We will also investigate to see whether if it is a child abuse case, but mandatory reporting is not required. In another case, if we notice bruises on the child and this child is still very emotionally disturbed, in some particular cases, the child is already recovered from the bruises, but they keep losing weight and have obvious mood change, then they are still at real risk of abuse because it may not be a one-time incident. Because of her marriage, the emotion of the mother is still unstable. In that case, the child is at real risk. Or apart from the old scars, there also are some new injuries that we believe that the abuse is continued. It is happening at different times. Then the child has been suffering serious harm. And reporting is required. In our next meeting, as we discuss the mandated reporter's guide, we will list out different criteria and scenarios. We will show you whether or not we need to have mandatory reporting under such scenarios. Hope that by doing so, we can share with you our analysis framework. Thank you. It is a very clear explanation. When I first look into the bill, we find that the professionals are highly liable. But now I believe that it is very narrow. Is it precise or narrow? According to our general understanding, I believe that the scope is very narrow. Well, in your draft bill, the scope is not as broad as we first imagined, but still you will exhort all means to encourage the professionals to report to you when they spot such cases, and you will also take care of them. The mandatory responsibility is focusing on such narrow scope, which mandated them to report, because if they do not report it, there will be legal consequences. Is that correct? Yes, it's correct, because we are talking about some statutory responsibility. If you do not report, you will be liable. For other cases, if they still believe that there are needs to report, our reporting mechanism will still be open to them, and our staff will investigate into it. Whether or not it is a child abuse case will take further investigations. But Mr. Lai, you have understood the situations correctly. Next, during Kwok.
Thank you, Chairman. Is suffering serious harm and has been suffering serious harm. What does that mean? If a child is suffering or has been suffering serious harm, how can the harm still be at real risk of suffering serious harm? Can you use the word and instead of can you use the word or instead of and? It's not like both conditions have to be met in order for the mandated reporter to make a report. Say a professional comes to notice some wounds or injuries. After assessment, the professional may think that there is no real risk, or the parents of the child have become stable and would not continue to abuse the child. However, no one can foresee the emotional status of other people. How can we ensure that the perpetrator or abuser can be emotionally stable in the future? Like the case brought up by the chairman, the perpetrator promised that he would no longer get drunk. But then what if that person gets drunk again? Under such a situation, would the professional have the statutory duty to make a report? Because when the professional assesses the case, he or she is of the view that the perpetrator is stable. But what if the perpetrator loses it again? Would the professional be held accountable? Mr. Ho, we have amended Schedule 1A, and it provides for definitions of serious harm. The serious harm could be physical or psychological. We aren't focusing on the actions of the abuser. We have to make sure that the child who is abused continues to sustain injuries. We're not focusing on the actions of abusing the child. Say a child is suffering from bone fractures, and when the professional sees the child is still suffering from bone fractures, which is included in Schedule 1A. If the professional comes to notice such situations, then he or she will be responsible to make a report. In relation to unforeseen or unexpected circumstances, the professional will have to make a judgment of whether there is a real risk. Even though a perpetrator may make certain promises, we still cannot ensure that the perpetrator will fulfill the promises. So we would expect in such situations that the professionals concerned would still make a report so that the police or the SWD can step in and we can formulate a social welfare plan for the child concerned to make sure that the child will not suffer from further abuses in the future. We cannot rely on the sole accounts given by the perpetrator. If the professional is of the view that there is a real risk, then we encourage the professional to make a report. So reporting to the police will not be the only option. We want professionals to step in serious cases. Do you mean that reporting to the police is not going to be the only option? Well, reporting to the police is part of the procedure. Perhaps I'll ask the SWD to tell you more. Say a child suffers from serious harm. It is important for the police and the SWD to intervene. By stepping in, the police can immediately stop the child from suffering serious harm or abuse. The SWD can also help make a judgment on what would be in the best interest of the child. Say, the SWD would decide whether the child should go back to his home, or whether the child should be sent to a residential care home, or whether professionals will have to step in to help the child. So we need different types of professional support in serious cases. Chairman, sorry, I don't think the administration got my question. I want to focus on the word "and". Because if you use the word "and", then it means that all conditions will have to be met. Also, the question about professional. If the conditions are met, does that mean the professional would not have to make a report? Well, I don't think that should be the case, because we want professionals to step in as early as possible. As you mentioned just now, you encourage professionals to make a report. However, if you have to have the two conditions met in order for a professional to make a report, that would be somewhat complicated. Say, when a mother talks to the child's teacher, she is not hitting or abusing the child at that time. And when I talk to the mother seems sincere and she promises not to hit the child again, and I decide not to make a report. So what I'm saying is that, can we not have all the conditions met at the same time in order for a professional to make a report? It should be made an either-or case. For instance, I know that a student got hit by someone with a rattan stick, and when I saw that student, the injuries or wounds were already recovering. From my professional judgment, I think I should make a report. But it's not up to me, because you're saying in the bill that you have to have all conditions met in order for a professional to make a report. Sorry, I have to interject here. I think Miss Lillian Kwok is bringing up a real-life situation. Say we know that a child has been hit, and the parents of the child talk to the child's teachers and promise not to hit the child again. In face of such a situation, say the parent begs the professional not to make a report, what should the professional do? I think Ms. Kwok is mixing up actions with the child's injury. By serious harm, we are not just looking at what kind of abuse the perpetrator has inflicted on the child. If you look at Schedule 1A, it involves serious harm, involves bone fractures. We are looking at the phrasing of the provision. As a counselor, as a professional, I understand that the child might be suffering from different types of harm. A teacher, for instance, may not be able to immediately notice what kind of harm a child is suffering. Does that mean in such cases the teacher would not have to make a report? Say a child is suffering from a serious psychological harm. I once came across a case in which the child was asked to take off all his clothes by his mom. Ms. Kwok, according to Undersecretary, the administration cares about what types of serious harm the child is suffering. We're not focusing on the act of the perpetrator or abuser. We have to look at whether the child is suffering serious harm. Chairman, in such a case, then the word "and" here is not used appropriately. Chairman, a child may have been suffering serious harm, and when the professional meets the child is still suffering serious harm. Say, even if the wounds are recovering, and the professional may still be able to take note of the scars of the child. This would fall within clause 4 bracket 1b, and it would warrant a report by the professional. So we're listing out the two conditions here. Has been suffering means the child suffered serious harm and is still suffering serious harm. In the Chinese translation, we want to reflect the same meaning. It is equivalent to what is drafted in the English version. I hope Ms. Lillian Kwok can understand the way we phrase the provision here. Ms. Kwok. I think has been suffering serious harm refers to only one situation, but in Chinese it refers to two conditions having to be met. Can you refine the wording of the Chinese so that we don't think that two conditions have to be met? Well, in Chinese, it says 影周受. It means the child is still suffering serious harm. I hope the administration can review the Chinese version of the provision here. I see that a number of members are waiting to speak. Miss Judy Chen. I think I understand what the administration is saying. My worry is that the professionals that are the mandated reporters are able to understand the same. The administration mentioned about some one-off incidents, but say I'm one of the professionals within the 25 categories listed out here. I would look at Schedule 1A. There are different types of serious harm, including physical and psychological harm. By common sense, we know that there are different levels of child abuse. An abuser may simply hit a child, but the abuse may escalate through time. We cannot look at child abuse cases as one-off incidents. There are very few cases like these. A professional, in order to protect himself or herself, he or she may make a report no matter what. And you ask professionals to fill out a form when they make a report. Do you offer an option to the professionals to make a pre-report instead of filling out a form to denote that they are making an official report? This involves Clause 6. Clause 6 talks about a form that professionals have to complete when making a report. Well, to be frank, I don't know if the mandatory reporting regime would work if we see cases as one-off incidents. Say there may be scars or wounds on a child after suffering serious harm. If I look at the scar, I would doubt whether the child would continue to suffer serious harm. Next, Mr. Peter Xu. I agree with Ms. Lillian Kwok. In the Chinese version, it says 已遭受並仍遭受. It means has suffered serious harm and suffering serious harm. According to the administration, a child who suffered from serious harm in perhaps an one-off incident. How can a professional assess whether the child abuse would persist? Say a child gets hit and he is injured all over his body. Would the parents of the child still bring the child to a doctor? Of course, the parents would wait until the child has recovered to bring the child to see a doctor. And by the time the child sees a doctor, his injuries may have recovered. We have seen a number of child abuse cases in recent years, and therefore we're asking professionals to help make reports. I think you're allowing too much room here for professionals to make a judgment. You should ask the law enforcement agency to make a professional judgment. You should not rely on, for instance, a speech therapist or a Chinese medicine practitioner to make a professional judgment. This would make things complicated. Well, say I'm a professional, it would be hard for me to make a judgment on whether the parents would continue to hit a child. Well, we will spell it out clearly in the mandated reporter's guide. That's the first point. Secondly, Mr. Peter Xu said professionals may not be able to make a good judgment. Say, for instance, a child sustained certain injuries and the professional, by looking at the wounds and injuries, think that there is a chance that the child may still be suffering serious harm in the future, then of course the professional will have to make a report. Mr. Xu, well, if I don't see any wounds or injuries, how am I supposed to make a report? What if there are internal injuries that I cannot see from my naked eyes? If the child has recovered from the injury, of course you do not have to make a report. Chairman, apart from the different types of serious harm that we have to look at from Schedule 1A, we have to see whether the child is at real risk of suffering serious harm. We have to make sure that the child abuse happens recently. And if the professional sees that there is a real risk, then of course he or she will have to make a report. Chairman, let's say a professional comes to notice some injuries on a child's body, and the professional may ask whether the child causes the injury himself. Well, if it is found out that the child got hit by someone, then of course the professional will have to do something. I think Mr. Xu is saying that for professionals who are not engaged in child care, say Chinese medicine practitioners or Western medicine practitioners who are also included in the list of mandated reporters, they may not be able to make a professional judgment.
括一
Maybe the DFJ can elaborate on this. Now, we are focusing on the children. And let's take a look of 4 bracket 1b, small Roman 1 and 2. If a specified professional observes or notices a certain state, and namely the serious harm, of course, we won't just look at 4.1b1. We have to look at 4.1b2 as well. We have to look at both conditions, and we should focus on the child. Well, probably some members have got it wrong in relation to focusing on the perpetrator or the persons in charge and their conduct. I hope the DFJ can elaborate. I used to be a law enforcement agent. Well, if a law enforcement agent acts in a certain way, and let's take a look of section 10 of the theft ordinance. If somebody steals and right before stealing or in the course of it uses force, so acts are involved. But in this bill, nothing is mentioned about the acts. And then for Cap 212, offenses against the person, section 19 talks about wounding or occasional actual bodily harm. It says that if somebody unlawfully or maliciously wound other persons, and whether whether weapons or tools have been used, then it is still an indictable offense, and it is imprisonable for 3 years maximum. So DFJ, please explain clearly. For 4.1, do you expect the specified professional to observe the condition and then comes to decide on whether there is a duty to report or not? For clause 4.1, in relation to the offense, for the actus reus, I think that's in relation to failure to report. As to when the professional has to report, if a reasonable ground to suspect comes to his notice, that is, there has been serious harm or is at real risk of suffering serious harm, then he has to report. When compared with the examples cited by the member, that's in relation to the acts. As to the acts behind causing the harm to the child, that's in relation to the abuse, rather than noticing the harm here. Mr. Leung. Well, for the acts, I think it's a matter of whether the specified professional has reported or not. Report or not, I think it depends on the conditions, the state of the child, and then that would call for or not call for a particular act. Mr. Leung is right. We are talking about the third party, that is the specified professional making a report. So the professional has to observe the condition. As to the act of the abuser, I think after a report has been made, the police will carry out an investigation, and then another piece of ordinance will be invoked to penalize the abuser. Here we are merely talking about mandatory reporting. So it is about the state of the child, and they would decide on whether there is a need to report. Now, if members are of the view that 41B1 is not precise enough, would I say that at the material time that child has been abused and is still suffering from serious harm. In other words, there's no need to guess whether there will be another abuse. Abuse has been carried out and has caused serious physical harm, and that would call for reporting, right? No. The child sees the doctor or the professional. The professional won't be able to see the act of abuse itself, but only the consequence, the harm. If he observes the harm resulting from the abuse or the injury, and it is expected that the harm will continue, then there is a duty to report. Now, if the professional sees the act of abuse itself, then the professional must stop it. So I think it's a matter of the professional notices the physical condition of the child, physical injuries as well as the emotional state. In other words, the 4 categories of serious harm under Schedule 1A. I'm sorry, let me go to your schedule and draw some examples there. If under coercion, the child takes part in a sexual act, so it's an act. Of course, he or she would have been hurt emotionally, but if there has been no physical harm, no physical injury, how does it fit into your framework? Dear J. Well, in the case of Schedule 1A, a child having been coerced or enticed to take part in a rape, etc. Well, the sexual intercourse would be regarded as the harm if a child has been coerced or enticed. Say, for example, under possessional power to engage in a sexual act, we believe that surely the child would have harm caused to him. And so we believe that under Schedule 1A, they would have already constituted the condition to mandate reporting. Dr. Lam. For 1B, 1 and 2 aren't that clear for us to understand. Now, if somebody has been beaten up and is still suffering from that, then that would give rise to a series of problems, and it warrants reporting. Now, it seems that it is a matter of a child has been attacked or abused, or if you suspect that something like that has happened and has caused harm, it could very well be physical or emotional, and the harm hasn't been removed. I think that's what I understand it to be. Let me first of all not argue with you as to whether that should be the right standard to adopt to mandate reporting. If that's your intention, then probably you need to fine-tune your wording. Just now, the Deputy Secretary said that the specified professional may not know why or how the injury has been caused, but at least we know whether it is a matter of a fight causing a bone fracture, an attack causing a bone fracture, or a bone fracture from a ball game. We would certainly ask. We may not be able to be that concise in relation to questions asked in a court. So as long as we have got sufficient ground to suspect them, it is a injury caused by an abuse, then it would suffice. So I believe you'll need to fine-tune the wording. I would like to raise a possibility that you may not be clear enough here as to whether the harm has been eased. Well, if it is a matter of serious eye impairment, maybe it can never heal. Maybe 10 years ago, the father used a book to strike him, and the child is suffering from very poor eyesight. It took place 10 years ago. Has it to be reported? Or the joints have been affected by an injury suffered 10 years ago. He is still having mobility impairment. Is it mandatory reporting? The harm can either be a verb or a noun, so probably trauma is a better word. You have to consider whether the trauma is still existing and whether it is ongoing. So we need to sort it out. Administration, I'd like to thank Dr. Lam for his comments. This is not just for 4.1. We need to look at 4.2 as well. Dr. Lam referred to injuries suffered by himself. Then, of course, it's not a matter of mandatory reporting. Of course, we have yet to reach 4(2). We're still on 4(1). But we need to read that together with 1 as well. So that's my preliminary reply. We can only look at the harm rather than the act itself because we didn't see the act. Both 4.1 and 4.2 have to be read together. I think it's a matter of the wording. If the wording is unclear, harm can either be a verb or a noun, but trauma is certainly a consequence. That's the result, the outcome. Just now, you were very concerned about the effect of the harm which is still existing. But then, how do you know for how long it can persist? Trauma could be lifelong. Would it warrant mandatory reporting? Well, if the trauma is very serious, like lifelong, as Dr. Lam mentions, or if the child is still a child, and then it will be covered, there is a duty to report. Mr. Lai Tong Kwong, Chair, if I may make a proposal here. A lot of time has been spent on this, and many members have come up with many suggestions. Well, so far, we have been talking about serious harm. We know there's a schedule to the bill. We have yet to discuss the schedule. Therefore, we were superficial in citing our examples. Let me say a word here. For serious harm, it says that it endangers his life or harm that endangers a child's physical health and requires urgent medical treatment, like poor eyesight mentioned by Dr. Lam. In fact, it is mentioned here, loss of eyesight. If it is not a matter of loss of eyesight, then it is outside the scope. Or if there's no need to be admitted to hospital for immediate medical treatment, again, it is not to be covered. So I would suggest that when we come to the schedule, we go through the schedule, then allow us to come back to clause 4 to dwell on the wording. When we scrutinize the schedule, then a lot of scenarios would crop up. Then we can see whether there is a need to fine-tune the wording. I think in comparison, it may be more helpful. So that's my opinion. Let me continue with my own questions. That's in relation to 4.1. The very last 2 words in the Chinese version, 舉報, report. Let's go back to clause 2. Report means a report made under section 4(1). What does that cover under section 4.1? Under section 4.1, it talks about the conditions to be met. And then the relevant person must make a report in compliance with section 6. But then section 6 mentions that when you make a report, you have to use the form specified under Section 14. So if you only look at report and the definition for report, as to whether you have to read it together with Section 6 and Section 14 on its own, I believe that there is some uncertainty here. Let's set aside the interpretation of report in clause 2. Let's look at the literal meaning. Report, reporting the matter to the authority. It can take different forms. As long as I can achieve my objective, alerting the authority, then that's it. According to 4.1, that's not the case. You have to do so in compliance with Section 6 before it can be said that you have made a report. Under Section 6, it says, well, that's not enough. You have to make a report in the form under Section 14. Right in the beginning, our LA asked whether an oral report would suffice. Administration categorically said no, it must be in a written form. You have to fill out a form. So I believe that there would be certain consequences. Is that your main question? Yes, Chair. Our objective is to be able to identify the child, to help the child. Therefore, we need certain information from the reporter so that the administration can trace and track the child, and then we can handle the case instead of just telling us that somebody hit his son. And that's as to why we need a form. Under Section 6, certainly we'll have the opportunity to have a more detailed discussion. I think it is all because we want to be able to identify the child so that we can intervene and stop the abuse. So there will be more detailed discussion when we come into Section 6. That's where the question lies. Of course, we know that you need sufficient information. There are clauses upcoming. You have another word that is before the material time. You notify them, but then it would not be enough to notify orally. I would still be committing an offense if I fail to fill out the form. My duty would only complete after I filled out the form. So there is a gap here. Do you really want to that rigid, or you want to have sufficient information? Now you are imposing a specified statutory form. Let me bring up this question. Let me bring up this concern, so that when we reach clause 6 and 14, we can have more discussion. There are other issues arising from the need to report in a specified manner. I will elaborate on this point later on. So for 4.1, 12 members have already asked questions. 12 questions have been asked, so we've spent a lot of time on that. So finally, let me ask my question. And let me share my observation with you as well. It's a scenario. Say, for example, it is a registered social worker. He's no longer practicing. He's in the insurance field. He has good communicative powers because of his social work training. He comes to know about a child abuse case because the parent claims compensation for an accident. Now, this social worker is now working as a agent for insurance policies. Will he be covered by this bill? 4.1 says, during the course of his or her work as a specified professional. Chair, according to your example, the person is a registered social worker. but then he's carrying out work in a capacity as an insurance broker or agent. In other words, he is not mandated to report, but he's welcome to report. Well, somebody would query that this agent may always tell others that he's a social worker, a professional social worker, and so he has a strong sense of empathy. Now, people would query that this agent has got a lot of business because he has been boasting his social work background. Of course, a doctor can say that he's both a teacher, an actor, a social worker, etc. But then it depends on the capacity that he is carrying out his work, like a medical doctor or insurance agent. So despite his qualification as a social worker, if he is not carrying out the work as a result of that registration status, then we believe that it is not quite right to expect him or mandate him to do so. Otherwise, a doctor may have got other identities as well. Then following the same logic, then he will be bound by several pieces of legislation at the same time, and thus affecting his medical doctor's work. So it's better to adhere to what we have said in the bill.
Here is an observation. Just now we have spent a lot of time to discuss 4.1b.1. That is at the risk of it has been suffering serious harm. I think there is no controversies in the other item. If we reframe it as has still been suffering serious harm, because what we're targeting is both the physical and the mental harm that the child is suffering. Would you consider rewriting it so that it would be easier for the professional to follow your legislature? Chair, our intent is to exclude cases that is no longer in reach and those who are fully recovered. There are only traces of previous harm, then this is not our priority. We want to target at the child who are still under harm. We want to rescue them. Therefore, it is much clearer in English. There are different suggestions about the wordings in Chinese. We will look into it. But the English wordings are more accurate. We will consider how can we make it more accurate in the Chinese version. We understand your intent. You want to exclude any past cases that are fully recovered. So the serious harm is not an action. It is not the abusive action. I think it is very clear. You will consider rewriting it in Chinese, right? Yes. Yes, if there is no better alternative, you still understand our legislative intent. So if there is no further questions regarding 4.1, we can move on. Legal advisor. Thank you, Chair. I would like to draw your attention to if in violation of 4.1, there are 3 types of offenses. The first one is when professionals come to the notice of such cases and fail to report. Second is when they reported, but they did not report it as soon as practicable. So delay is also a crime. Third, the professional make a report, but as Mr. Lai suggested, they did not report according to the requirement of Section 6. Maybe the evidence is not enough, or they do not report it according to the statutory form. So please be aware that these are the three scenarios of the violations of 4(1). If they fail to report, this is not a crime of strict liability. For scenario 2, if they file the report without the statutory form, then it will be a strict liability. Thank you for the comments from legal advisor. If the professional has filed report without the statutory form in compliance with Section 6, then we do not have to prove the mens rea because they are already coming to the notice and the reasonable ground. They only report without in compliance in the Section 6, so there is no mens rea. But we still come to the notice of the mens rea. So it is not strict liability. Targeting at that particular element, we do not have to prove for the mens rea. Any follow-up questions? No. We will have a short break of 5 minutes at 11 o'clock. For bracket 2. For 4(2), however, as specified, professional is not required to make a report under subsection 1 because we will allow them to follow the similar guidelines of the existing rules. It also that we will allow them to continue to deal with the bullying cases, and accident is also not falling into the scope unless the accident is caused by neglect. Mr. Lai Tong Kwok, 4 minutes. Thank you, Chair. You have used the word solely. And in Chinese, we also see a junction. So this morning, we have received a submission from Ms. Doreen Kong. In the first part of her submission, she is also covering this part of my question. If you look at the wordings itself, so if such serious harm is caused solely by the following 3 scenarios, it means that the serious harm already existed because in English we say the word was. But then you have added the wordings is to be. Confusion is caused. Such serious harm is not yet happening. If it is not happening yet, it will be impossible for us to know whether it is to be caused solely by any of the reasons. It is impossible for you to predict something that is solely caused by a particular reason for a future event. As I read, I am very confused at this clause. Would the administration consider, as Ms. Kong suggested, shall we cross out or is to? It would be more direct and simple. Administration, may the DFJ explain why we include a or is to be. Thank you, Chair and Mr. Lai. The reason why we include the wordings is to be is to respond to 4(1)(b), 1 and 2 because it covers the past, that is what solely caused in the past. And also for B2, is at real risk of suffering serious harm. In other words, the serious harm is not happening yet. Say the child is not under serious harm at this moment, but they may convey to the professional that I'm planning to burn myself. Then they is at real risk of suffering serious harm because he has expressed that he plans to do that. So it will be falling into the category of is to be solely caused by. Then it will constitute a case that requires reporting. That is why we rephrase it in order to cover these scenarios. It is impossible for you to prove because it has not happened yet. You are only predicting a future event. But you also mentioned solely, caused solely. There may be a high possibility for it to happen in the future. For that, you can predict. But if you have to predict something caused solely by a certain reason, it will be very difficult. It is a very direct question. Of course, I understand what you explained about the coverage, but it is impossible for you to cover everything. I don't understand what's the difference with or without the clause. I understand what you mean, Mr. Lai. This is our intent. We intend to write it better. We will seek advice from the DFJ and consider how to take care of this internally. I have a follow-up question, Mr. Lai. Apart from the wordings is to be, do you have any opinions towards the word solely? No, not in particular. It is a very high requirement. But I do not have any opinions towards that word in particular. It is written in the manner of being exclusive. We have Ms. Judy Chen and another member. Just now, the administration has explained scenario 1, 2, 3 for bracket 1, an accident not caused by the neglect of a responsible person of the child. If it is an accident caused by a responsible person, then it will be covered. Is that true? Second, I would like the administration to explain about 3 because I cannot understand. Any other child who is not a responsible person of the child otherwise than caused by any act of a... can the administration or the DFJ explain it further? Perhaps you can explain with some scenarios. SWD? DFJ, thank you, Chair. Thank you for your question. What you understood is accurate for Part 1. An accident, if the accident is caused by the neglect of a responsible person of the child, it has to be reported for bracket 3. Any other child who is not a responsible person of the child, it means those who are aged 16 or 17. A mother at the age of 16 or 17, if they caused any serious harm, it has to be reported. Part 3 is trying to rule out bullying among peers. If we do not include it, then we will be excluding the abuse inflicted by a mother at the age of 17. Therefore, we will say any other child who is not a responsible person of the child. Is a mother a responsible person of the child regardless their age? Yes. It will see if they falls into the definition of a responsible person. If it is inflicted by a responsible person, even if that is a child, it still has to be reported. So now are you excluding them or not excluding them? We will exclude serious harm caused by any other child, because we want to exclude peer bullying. If we rule out everything, then we will be also ruling out a responsible person at the age of 16, 17. So that has to be covered. Going back to bracket 1. Will there be further remarks defining an accident? Generally speaking, we will take the ordinary meaning. I think it is already sufficient. Mr. Lai also asked about how to prove. In clause 2a, it mentioned that the professional honestly and reasonably believes. So there are grounds for them to believe that it is an accident. Even this is not the case at the end. When they decide not to report, they are reasonably believing that it falls into this definition, then that person will not be liable. After Lillian Kwok raised a question, we will take a 5-minute break. Thank you, Chair. Well, was or is to be caused solely by. Is it really important to put it that way? Would there be flexibility? Because you are excluding any other factors. If a child conveyed to you that I'm going to burn myself, if the person who heard about that did not follow up, or the person in charge just disregarded even upon repeated mentioning, and that child did burn himself in one incident, would that professional be responsible? Just now, Ms. Judy Chen also asked about 2A3. Any other child who is not a responsible person of the child. It is quite difficult to analyze, especially in Chinese. It's easier to understand in English. You explain that you just want to exclude child who are underaged. You want to exclude cases of peer bullying. Would you do it the other way around? It will be caused by not caused by any other child, excluding the responsible person of that child, because you only want to exclude one particular group of person. How can you make it clearer so that a layman can understand? I think our legislation has to be read and understood by a layman. Administration? Thank you, Chair. We will consider about the drafting. Because there is also otherwise in the bracket. If we use it twice in this particular part, it will be quite complicated. We will reconsider about the drafting. So we have covered 4.2 bracket A. We have a common understanding. We just want to see if there is any room for rewriting. Thank you. We will take a 5-minute short break.